Welcome to those of us who have just joined us. This is our panel discussion on Brexit and the choice of law and jurisdiction clauses, views from Germany, Ireland and Italy. First, by way of introductions, I'm Joanna Morris, Director of Commissioning at Practical Law and responsible for our Brexit coverage. I will be co-chairing this session with Laura Marianello, a Senior Editor in Practical Law Global. And I'm delighted to introduce our expert panel, Cecilia Carrara, a partner at Legans, based in Rome, John Cronin, a partner at McCann Fitzgerald in Dublin, and Christoph Wolf, a partner at Baker McKenzie in Frankfurt. As I'm sure you're all aware, we continue to be in an interesting stage of the Brexit process. The fifth round of negotiations concluded last week, and following on from Michel Barnier's comments on lack of progress, the European Council, which starts its summit tomorrow, is unlikely to agree to expand the negotiations beyond their current remit. This means that discussions will continue to focus on the withdrawal process rather than on future trade relations. In the meantime, however, the UK remains a member of the EU and subject to EU law and European Court of Justice jurisdiction. Even so, there is already some discussion, inevitably, as to whether the inherent uncertainties about the future legal and regulatory landscape might be leading to changes in market practice, one of which we thought we would explore today. I will now pass over to Laura to provide some background on choice of law and jurisdiction.
Thanks, Joanna. Traditionally, in sectors such as commercial contracts, finance, M&A or shipping, English law and UK courts or arbitration venues have represented a very popular, if not the preferred choice for cross-border transactions, even when the transaction or its parties do not have any geographic connection with the UK. The reasons for this choice have often been associated with the benefits frequently attributed to English law and its judiciary system. In particular, the transparency, certainty, flexibility and predictability of English law. There is limited scope for terms to be implied or public policy or other principles to override what has been freely agreed between the parties. In addition, the reputation for independence, reliability, expertise and commercial judgment of English courts, coupled with the willingness of judges to give effect to the contractual arrangements agreed between the parties. In this context, it is worth mentioning that the Law Society has recently launched a video campaign to promote the benefits of English law through its Global Legal Center, while English judges have explained the value of the legal systems in the UK in the recent brochure, English Law, UK Courts and UK Legal Services after Brexit. And also relevant is the UK government's intention to incorporate Rome I and Rome II regulations into domestic law. This would actually mean that EU member states court and the UK courts would continue to apply the same set of rules to determine the governing law of both contractual and not contractual obligations in most commercial contexts, and so would uphold the parties' choice on governing law clauses, subject only to certain limited exceptions. So English law's popularity may continue to be the case post-Brexit. However, we thought it would be interesting to hear from lawyers in other EU jurisdictions with experience in cross-border transactions and dispute resolution for their views, and to ask whether, from their perspectives, the prospect of Brexit is already leading to any change in the approach to the parties' choice of governing law and jurisdiction in cross-border transactions, and indeed whether any initiatives are taking place in their jurisdictions in anticipation of Brexit Day.
Thanks, Laura. So before we start with the questions, just a quick housekeeping point for listeners. You can submit questions during the seminar, and if there is time, we will put these to our panelists at the end of the session. If not, we will do our best to field these questions after the webinar. So without further ado, the first question relates to governing law. Just by way of background, a governing law clause enables the parties to specify the system of law that will apply to the interpretation of an agreement and its effect if a dispute arises. So, Christoph, starting with you, do you think that parties to a cross-border transaction have changed or may change their attitude to governing law in contracts as a result of Brexit? And might this approach depend on the types of agreements or transactions?
I think the answer is yes. Clearly, there are probably three categories. The first category being those where English law is the law of choice, and that will continue in many situations. That includes particular industries, that includes also particular situations with a nexus to the UK. There are other situations where English law is clearly not the law of choice, for instance, German domestic or French domestic situations, or even German-French situations where hardly people would go for English law. And then there is a third category, which I think is probably of most interest here, which is a situation where, for instance, you have a Scandinavian and an Italian counterparty, and where historically, for all the reasons set out by Laura earlier, parties think that English law is a good choice. And I think in these situations, the parties will look more closely whether that is still the case, and even more so whether English courts could or would be a good choice.
Thank you. John, what is your perspective?
I agree with Christoph. Legal certainty and legal predictability are key to international cross-border transactions. I'm a finance lawyer, so for me, the question is, what is the potential impact of Brexit on the choice of law and jurisdiction clauses contained in the many contractual documents that we use for debt capital markets, for securitization, and for structured finance transactions? So for me, the question is, will there be the same level of legal certainty, the same level of legal predictability in circumstances where, firstly, negotiations on Brexit are as yet unresolved, and where even their future direction remains unclear? Again, as a finance lawyer, one of the things we see is that it is possible that future financial regulation, which derives from EU law, will trend towards probably a preference for the use of laws and the courts of an EU member state. Certain examples of this preference can be found in recent EU legislation, and therefore the significant achievement of the European Union over the last number of years of the introduction of harmonized rules regarding key aspects of, say, cross-border litigation on such contracts, that may be undone as a result of Brexit.
Thank you, John. And Cecilia, what are your views?
Yes, thank you. I very much agree on the points that Christoph and John already made. So I think that financial contracts may still be an exception. So in these cases, it may still be that there will continue to be a preference for UK law, maybe just on the basis of what the tradition has been so far. In all other areas, being a continental European lawyer, I think that already today, unless there is a clear connection with English law between non-English parties, it would not make particular sense to choose English law as a neutral law in consideration of the uncertainties that there will be or may be or are already as a consequence of Brexit. So going back on the example that Christoph made initially, in the case of an Italian and a Swedish counterparty that would agree possibly to English law as a neutral law. I think that in a situation like this, there might be other legal systems that could nowadays be more appealing as neutral venues, remaining in the realm of what is the European law. So I think that legal systems like Germany, France, Switzerland, even though Switzerland has a peculiar situation as well, may be in the short, medium term more friendly or appear as a better neutral choice to non-English parties.
Thank you, Cecilia. And Christoph, and also John and Cecilia, do you think that it would make a difference whether the relevant contract in which a governing law clause is inserted as a duration that goes beyond Brexit or not, or at least certain of its effects will last post-Brexit? In other words, do you think that there is a short-term perspective versus a medium-long-term one that the parties are considering or should consider in choosing a governing law?
I would fully agree with John. Legal certainty and legal predictability are paramount, and as a consequence, I would see, and we do see in practice, a gradual starting movement away from English law, because people want to be certain what is the situation, even if they have to litigate in a year or 2 years down the road. I mean, there can be all kinds of ramifications further down the road. And if you now see the Brexit coming or looming, and you are afraid it could be a hard Brexit, there's a lot to be said to think twice before using English law in situations of the third category, as previously explained.
Thank you.
Thank you, Christoph.
And now moving on to jurisdiction clauses.
Yes, which is the...
I'll just add a point, Christoph's point there. I think we would agree in Ireland that the assessment that many English law firms are making regarding the current regime on governing law being preserved post-exit, and that contractual governing law clauses will continue to be upheld in the UK courts and in the EU 27 national courts as they are today. But it's the confidence point that goes to the core of the issue here. And if you think about some of the financial law transactions that I mentioned earlier, typically one gives legal opinions on the basis that, and on the assumption that, Britain is and will remain a member of the European Union. And clearly lenders, purchasers of new securities rely upon that and accept those assumptions as being normal and indeed sensible assumptions. Going forward, post-Brexit, that's not the case. And that immediately, so to speak, brings a level of uncertainty. I wouldn't overemphasize the level of uncertainty, but it brings some uncertainty. And what Christoph referred to as being some changes in people's attitudes towards accepting English governing law clauses, it may be a tiny, tiny trickle. It is discernible.
Thank you, Christoph and John. And Cecilia, I don't know if you want to add anything to this.
Well, nothing in particular. I think that it's very difficult to say whether there should be a distinction in decisions short-term versus medium-term, as you asked initially, Laura. I think to a large extent what the parties choose to do is also a consequence of what their lawyers suggest that they should do. And I think not just in the short term, but more medium-long term, the fact that the lawyers' community may change and that the business centres may change in the way they are composed may also ultimately reflect the recommendations that lawyers give to their clients in terms of practical tips and choices on the applicable law. So I think, I believe it is more likely that we will see a greater uncertainty and reluctance to choose English law for those situations that have a longer impact in terms of duration and time involved in issues arising.
Thank you very much, Cecilia. I think the last point you made is something we may come back to later, and I think is an interesting one for its potential consequences long term. What it seems to transpire from what you all said is that uncertainty at the moment seems to be driving the parties' choices anyway. So, as Joanna was mentioning, moving on to the other topic of our discussion today, it would be interesting to hear the views of our panel on jurisdiction clauses. A jurisdiction clause, just to give a bit of background, is a dispute resolution clause which aims to identify which court or courts are to hear a dispute. And of course, parties to a transaction may alternatively agree to arbitrate any future dispute that may arise and include an arbitration clause instead. Cecilia, given your experience both as an arbitrator and as a counsel to parties involved in cross-border disputes, do you think that the choice of English courts as exclusive jurisdiction could become less popular as a result of Brexit? And again, is this also driven by the subject matter of the dispute?
Thank you, Laura. Yes, I think that it is likely that jurisdiction clauses in favor of English courts will be less appealing to the eyes of the party, and I say this because there is always a clear risk in referring a dispute to a court that would be applying a different law to the merits than its own national law. So if we assume that it will be less often the case that the parties select English law as applicable law, in this scenario, it also makes less sense for the parties to choose the English courts as those having exclusive jurisdiction. Moreover, we all know from a comparative experience, practical experience, that the cost of litigation in front of the English courts is particularly high. So if we will become more familiar to situations where international contracts are less governed by English law, there would be even less incentive in selecting English courts, both due to the fact that they would have to decide on a law different than their own one, and in view of the high costs that litigation in front of the English courts involves. It might be different for the selection of a seat of arbitration, but I understand that may be a different point.
Thank you, Cecilia. And John, what is your view from an Irish perspective on this topic?
We do see some trouble ahead potentially here. We think there are risks arising from Brexit in civil disputes. For example, there may no longer be a passporting right to automatic enforcement of judgments. There may be some inconsistency between the powers of the English and the EU courts. There is some potential, we believe, for satellite disputes regarding jurisdiction and enforceability. There is some risk, we believe, of conflicting parallel litigation. We believe that the balance of risk in certain commercial contracts could change in unintended ways. The taking of evidence could be inhibited, and there could be some loss of mutual assistance measures. I wouldn't overemphasize any one of those points, but taken together, they do aggregate into some risks that some parties and some clients may feel are inappropriate. I'd also mention one area, if I can go back to my own area of financial services law, and identify MiFIR and indeed AIFMD, which have, and these are recent pieces of legislation, if you like, at EU level, and they contain provisions that require investment service providers from third countries, in certain contexts, to offer to resolve disputes before the courts of an EU member state. And such provisions will obviously impact on the choice of English law and the jurisdiction of English courts following Brexit. You may take the view that these provisions, having been included in fairly recent pieces of financial services legislation, it's possible they represent a trend towards a preference for the use of the laws and the courts of EU member states in transactions which come within the ambit of EU legislation. And if there were further provisions introduced in future EU financial regulation, that could undermine choices made by parties in their documentation in favour of the laws and courts of third countries, and therefore potentially reduce the attractiveness of choosing the laws and the jurisdiction of non-EU member states, such as the United Kingdom.
I would only want to quickly elaborate on 2 points, one made by Cecilia and one made by John. I think if you have a governing law, take English law, you may naturally go for English courts, and I'll specify that in a minute. If you were to have governing law, for instance, French law as governing law of your contract, there's no way you would normally choose an English venue. There's no point. And conversely, if you had English law governing the contract, there's no one in the world who would choose French courts normally. In particular, because those courts are not familiar with the law. So typically, the jurisdiction follows the governing law. Now, I think Cecilia pointed rightly out that indeed English courts are relatively expensive, and therefore already when you choose English law as governing law, typically we advise our clients, and I think everyone on this panel probably advises their clients not necessarily to go for English courts unless you want this situation to arise that it is particularly expensive to litigate. For instance, in a situation where you are more on the side of the potential defendant and where it may be interesting and helpful to make it more difficult to disincentivize the other side from suing you in the English courts. Second point I want to make, yes, we've heard about the UK wanting to implement Rome I and Rome II into its national law, and I think that is a good movement, and it is probably to be expected that there will be a similar echo at the EU end, or maybe in all the member states. But again, following up on what John said earlier, it is far from certain that that will be the case, even if the UK were to do that.
Thank you, everyone, for your insightful views on this. And I would say, as a related question to this topic, do you see arbitrator panels to be somehow on the rise, and so arbitration clauses to be considered by the parties as an alternative now, even when English law is the governing law, or when another law is the governing law of the transaction? Cecilia, do you want to start on that?
Yes, thank you, Laura. I think that with regard to arbitration, Brexit could be more neutral. That is because arbitration panels are generally more used to and suited to decide a dispute on the basis of a law different from the law of the seat. So even nowadays it is common to have arbitration proceedings seated in the UK UK, where the arbitrators have to decide on the basis of a law which is not English law. So in these cases, because the legislation that applies to recognition and enforcement of international awards is not entirely, I would say, national. So the New York Convention is the major convention governing the issue, and it would remain untouched. The situation would be, in my view, less affected by Brexit, even if it were to be a hard Brexit. Moreover, there would, of course, still be a big potential for London as a seat of international arbitration proceedings in all those cases where there are international parties involved, i.e. European and non-European parties. So London would maintain its appeal as a truly international center, and maybe its image of a neutral center could be even more enhanced. So I think that whereas for continental parties, so in the example that Christophe was making at the beginning, Italian and Swedish counterparties, or it could be a German and a French one, it will be more unlikely also for arbitrations to select London as a seat. It would not be the case for all those cases where there are non-European parties involved, where actually London could maintain and even increase its role of a neutral venue. So I think with regard to arbitration, Brexit could be more neutral, and the competition that London will have to face in terms of attractiveness of seat of international arbitration is not only the one of the European traditional arbitration centers such as Vienna or Milan or Stockholm, but Paris, of course, but also the new, very successful rising arbitration centers in Asia and of course the US. So as a conclusion on the point, I think that the possibility to maintain attractiveness of London in particular as center of international arbitration will be less affected by Brexit as opposed to the selection of English courts as the courts that would have exclusive jurisdiction to hear international cases.
Thank you, Cecilia. This is very interesting. Christophe, are you seeing something similar in Germany, or is your experience different from what Cecilia has just discussed?
Well, maybe 2 points. First of all, unlike Cecilia, I'm not a litigator or an arbitrator. I'm an M&A lawyer and capital markets lawyer. Therefore, my approach is somewhat different. And I must say, personally, I don't see a lot of that. I'm discussing this with my litigation partners and with colleagues in other countries, and that's what I'm condensing in this discussion here. But personally, I don't witness that a lot. I'd like to ask a question to Cecilia, though, which I'm really interested. I know that we as a firm typically don't prefer the London Court of International Arbitration, the LCIA, again for cost reasons, and therefore we would tend not to recommend London necessarily as a place of jurisdiction, even for arbitration. And then if there is a move away from English law, I wonder whether that should not have at least as big an impact on the London Court of International Arbitration as on the English ordinary courts, because normally, for instance, if you have a French law or German law governed agreement or contract, you would not go for London arbitration anyways. You'd go for potentially Paris. You would go for the DIS arbitration somewhere in Germany. There are different choices. Switzerland potentially. question to Cecilia whether that may not also impact the LCIA at least.
Sure. Thank you for the question. I'm very happy to respond. I think that there have been so far different views expressed on the point. Of course, the LCIA says it will not be affected. In my view, I think it's difficult to predict precisely. I agree with you that in very general terms, at least London would be on exactly the same competitive basis as Paris or Zurich or Geneva if there is no English law element in the dispute. So the choice would be based on the friendliness or not of the English Arbitration Act, for instance, the kind of support that the English courts give to arbitration or non-support, and whether or not more generally London would be perceived by international parties as a neutral venue and maybe a preferred venue for whatever reasons as opposed to Zurich or Paris or Frankfurt. So for instance, traditionally London has been considered a neutral venue and has been selected often by Russian parties in all kinds of disputes involving also non-English parties. So there may be, and for Asian parties it could be the same, that London may be considered historically closer and more neutral with regard to Paris. So I think here it's more a question of competition between arbitration institutions, so LCIA, ICC, Milan Chamber, DIS, I don't want not to mention anybody in particular, but there may be reasons that go beyond the simple element of cost, also because in my experience the cost factor is quite comparable between the institutions. A lot would depend on the value of the dispute. So we know that the LCIA system is based with regard to the arbitrator's fees on hourly rates, whereas the ICC system and the majority of other systems in Europe has an ad valorem system for the fees. More and more arbitration institutions are introducing fast-track procedures also in order to limit the costs involved in arbitration. So I think, of course, if more generally London will be perceived as a less attractive option as opposed to others, to some extent the choice of London as seat of arbitration will also suffer, but I don't think that there is a immediate legal reason for that. It would be more a soft factor, so to say, or persuasive element of the lawyers in indicating to their clients a venue as opposed to others. In the choice, a final point on this, it is also very significant when choosing the seat of arbitration to consider what would be the pool of lawyers based in a certain place that could be potential arbitrators or counsels involved. So to a large extent, if there is a big and specialized community in a certain forum, that is likely to attract, by definition, more international work, including arbitration work specifically. So cities like London, Geneva, Paris, that have a strong arbitration community will, in any event, at least in the short term, continue to attract equally a certain kind of work because it comes from the recommendations of the lawyers. If, however, in the medium term, the community of lawyers in certain parts of the world and cities will change, we will also see, I guess, a shift in the selection of the seats of arbitration.
Thank you, Cecilia, for your comprehensive answer. And
John,
yes, John, please, would you like to add anything to this?
I'm a banking and finance lover, so I know very little about litigation or arbitration, but my understanding is that the rules in arbitration will not be affected by Brexit. And to the extent that issues of governing law arise in the context of an arbitration, the current regime will continue in force. The fact is that in financial law matters, London is preeminent and will continue to be preeminent, certainly in the foreseeable future. It's the soft point that Cecilia has just mentioned. Will the same level of confidence reside in the use of an English jurisdiction continue? Will the same level of confidence reside in parties in relation to how they will be treated? It's intangible in some ways, but I do think the preeminence of London in relation to financial law matters is not going to change anytime soon, but you may see a slow, perhaps a very slow, but perhaps also an inexorable slide away from the use of London as an arbitration centre, or indeed for the settlement of financial law matters.
This is Christoph. Very quickly, maybe for the benefit of the audience, why go for arbitration as opposed to ordinary courts? Essentially 3 reasons, and I think the third one is by far the most important one. A, confidentiality, i.e. no public court proceedings. B, speed. We still believe that these processes, these procedures are quicker than ordinary courts. And C, and most importantly, there's no problem whatsoever to essentially execute your judgment in any jurisdiction of the world, even where there are no treaties among countries like, for instance, Russia and the UK, or Russia and Germany, or the US and France. In all these situations, when you have an arbitral award, you can very easily execute and foreclose on that basis. So that's the main advantage over all other regimes. And then, as already mentioned, under Rome I and Rome II, essentially within the EU, you have achieved the same thing for the ordinary courts, but that is a real exception. Other than that, it's always much more difficult to enforce your judgment abroad.
Thank you very much to the 3 of you for your interesting views on this. I think to sum it up, we could say that arbitration may somehow be on the rise, but London may continue to maintain its central role for international arbitration. And also the potential lack of confidence and the continued uncertainty that the Brexit is generating may somehow have an effect on that. But this is still to be seen. So I hand it over to Joanna now, and we can move to the next slide and set of questions.
Thank you, Lara. So moving on to perhaps the wider picture. John, starting with you, I was wondering whether you think that your jurisdiction could benefit from the uncertainty arising for Brexit, and whether there are indeed any initiatives in your jurisdiction to promote the use of local law and courts as an alternative to English law and courts.
Well, I'll answer the first question first. We, as a firm at McCann Fitzgerald, have looked at the financial services world and tried to identify whether there are opportunities for Dublin, as obviously there may be for other jurisdictions as well. So we've looked at banking, we've looked at insurance, we've looked at asset management and funds and custody and back office services, and we've looked at fintech. In the first category is banking, and I think it's clear that the major international banks are going to go to Frankfurt. 1 or 2 may go to Amsterdam, possibly Paris as well. But the big international banks look as if they're going to relocate to Frankfurt. And that probably makes sense. The ECB is based in Frankfurt. The balance sheet size of those banks is such that it probably makes a lot of sense for both the regulator and for the banks themselves to be based in Frankfurt. On the insurance side, I think both Ireland and certain other jurisdictions, we're talking about Luxembourg, possibly Belgium, possibly France as well, will see, I think, some leakage from London to Ireland and to the other jurisdictions as well. That is happening already, and it's public knowledge already, and to a small extent that will continue. In the funds and assets management situations, it's very clear indeed that there is already some movement towards both Dublin and Luxembourg in particular, possibly also to Amsterdam and to Paris. But it's very clear that both Dublin and Luxembourg, which have very significant funds and asset management market slice, I think that is continuing with some pace, I would probably say. I think I would also say that those international banks that are already in Ireland, talking about JP Morgan, we're talking about Barclays Bank, we're talking about Bank of America, Credit Suisse, it's likely, if not more than likely, that they will expand the range of activities that they carry out from Ireland. And it's probably correct to say that those banks have made applications to the Irish Central Bank to expand those range of activities and the license activities they may carry out from Dublin. And the final category is in fintech. It's worth noting that of all the activities in that sphere carried out at present, almost 70% of the activities in Europe, of the European Union, is carried out in or around the UK and particularly London. Some of those activities are going to have to move for distribution reasons and for other reasons. And we would see some of those activities moving to Ireland, and some of them will be moved to Paris, maybe Amsterdam as well. So it's not an enormous chunk of business leaving London, but it is a significant piece of work, and we're definitely seeing that. And there's increased slow but inexorable momentum in that regard. Outside of financial services, it's probably true to say that Ireland, because it will become the only English-speaking member of the European Union, because it has a common law system, and therefore has a lot of the predictability and the certainty that the English common law system has, will be an attractive location for, say, multinational companies that might traditionally have looked at going to the United Kingdom. If you take, for example, Canada, which has recently signed a comprehensive and economic trade agreement with the European Union, the so-called CETA, typically one would have expected Canadian companies to look to the United Kingdom in which to base themselves. Going forward, it's possible they may look to Ireland for precisely the reasons I mentioned previously. Similarly, if you look at India or if you look at Australia, which would almost always have looked in the first place at the United Kingdom, there probably will be questions asked in each of those jurisdictions and by the lawyers in those jurisdictions as to whether other jurisdictions, such as Ireland, may now be considered as appropriate or safe places on which to base new enterprises which are looking for a platform into the European Union market.
I would fully concur with that. Maybe a few points to set the wider scene. I mean, let's be honest, every one of us, and for instance, I'm a German lawyer, every one of us has a home bias. So probably Cecilia has a home bias towards Italy, probably John has a home bias towards Ireland, and I certainly do have a home bias towards Germany. As a firm, we, fortunately, at Baker McKenzie, we happen to be in the comfortable situation that we are agnostic. We can cater to clients' needs as much under French law as under UK law, as under US law, or indeed German law. Secondly, there's probably a secular trend towards more demand for local law, and that may go hand in hand, interestingly, with phenomena like Brexit, like the election of Mr. Trump, like other things we are seeing, which may or may not be helpful, but I think there's probably a cultural trend towards more local law, be that a good or not a good trend. Thirdly, which jurisdictions would or could or will benefit from that? I think many probably. We certainly see a country like Switzerland benefiting from that, and Swiss law is certainly traditionally a law we recommend as a firm. The bigger European countries will probably benefit from that. That includes countries like France. Other countries, difficult to say. I think Cecilia pointed to Asia, and yes, there is something to be said in favor of Asia. The US, maybe not, among other things, because it's so expensive to litigate there. And then maybe one last point, which is obviously key, language. As you will have noticed, we're speaking English on this call, and we're not speaking Spanish or German. And that's for a very good reason. English is the international language, and the use of the English language in a court is very important and very, very helpful. And that is probably also what helped promote English law so much. For instance, in Germany, there are certain efforts to allow English law also as a court language. I think if you choose arbitration, you can avoid the issue, because in arbitration you can obviously have your proceedings in English. But the English language is really key, probably even more than the governing law, in order to be able for parties to choose a particular law.
Yes, and from my perspective, I think it would be very tough to say and improbable that Italy would be in any position to benefit from a situation like Brexit as a jurisdiction, and I wouldn't want to make that statement in any event. But I very much concur with the general remark that Christoph made, that we are experiencing in general a trend towards more national approaches, and we may all have our views politically on whether that is right or wrong, but that is a fact. And so there might be more room in the next future for national laws with respect to national dimensions. Moreover, if we will see high-level professionals until now based in the UK returning to Italy for whatever reason, or relocating to Frankfurt or elsewhere, then of course this will bring with it, to a certain extent, also a shift in legislations that these individuals will be selecting for their commercial transactions. So I think it would not be fair or right to say that the Italian jurisdiction per se would benefit from Brexit, but there might be a return and a broader use of Italian law as a consequence of a relocation of high-level Italian residents currently in the UK, for instance.
Thank you all. And Cecilia, I was just wondering whether there are any particular initiatives in your jurisdiction to promote the use of local law and courts that you'd like to mention or expand on.
Thank you for asking. I think unlike in Germany, there haven't been initiatives so far to promote, for instance, the usage of English as a possible language with regard to international commercial disputes. We are experiencing a trend in the past years of a higher degree of specialized commercial courts, also to respond to the requirements set by the World Bank in its rankings. So there is generally a trend going in the right direction, but we are not at the level of promoting international proceedings in front of the Italian courts. We do have, however, a very well-organized, and I'm doing a bit of promotion here, a very well-organized arbitration institution in Milan, which deals with international cases. And of course, as already mentioned, in the context of arbitration, it's definitely easier for the parties to select any language that the parties may want, and to have a neutral venue, even though the seat is in Milan, and the arbitration legislation that we have in Italy is generally in line with the UNCITRAL standards, with the international standards. So we are a good venue for international arbitration, generally speaking. The kind of lobbying activity that has been done by professional entities in Italy in the recent months is more specifically focused on trying to attract the EMA to Milan, which has announced the necessity to leave London. So I don't know whether you would want me to expand on that now, or maybe we can get back to this point.
No, I think, Cecilia, if you want to expand on that point, it would be good, because I think we have seen the recent press release on that. So it would be good if you want to expand a bit.
Well, sure. I think that there are no official news yet, but it's all over the newspapers in these days, and in Italy in particular. So Milan is among one of the possible candidate cities to host the EMA, now that it will have to move from London. There are competing venues, in particular Stockholm or Amsterdam, Vienna, but Milan is among the preferred cities, and I understand that also the staff of the EMA has expressed a liking to the possibility to relocate to Milan. Traditionally, Italy is still a very strong center for life science companies and for the pharmaceutical community in general. And of course, a potential relocation of EMA to Milan would also imply an attraction of international disputes related to the field of life sciences and pharmaceutical products and IP in general to Milan. So there is a certain expectation with regard to this possible move. And just to give you an example, the topic of the annual conference that is usually held in Milan at the arbitration chamber in November is going to be precisely on arbitration in the IP sector. So I think there is a growing interest in general for arbitration in IP disputes. And of course, if EMA were to relocate to Milan, there could be a pool of professionals that would also consider relocating around the EMA, not only legal experts, but of the field in general. And again, this is one of those soft elements that could determine an attraction also of the legal community operating in the field, and then in turn a rise in the international litigation and arbitrations that could be hosted and seated in Milan. The city is definitely in line with European standards as regards overall services, and I personally think it's well equipped to compete with some of the other North European cities on the point. So in short, there is quite some expectation that at least the EMA could come to Italy, and so the banks, we are also seeing, as Christoph mentioned, that they are more likely to move towards Frankfurt. So let's see.
Yeah, thank you, Cecilia. That is an interesting point to see where, as you said, the European Medicines Agency will move, and also where the other European authority currently based in the UK, the EBA, will go. In relation to this, and also to the point that John made earlier about financial services, Christoph, would you like to elaborate a bit more in relation to the banks, that we have seen at least some of them making plans to expand their European offices in other member states. What are you experiencing in Frankfurt, and what are you seeing in that respect?
Yes, of course. Thank you, Laura. I think John already summarized the position very well. And what's very interesting is where do you get the news from? Sometimes there are official statements. There's an official statement from, I think, probably all the big Japanese banks, save for one, or probably there is an official statement from everyone. But save for one, they said they will move operations or some of the operations to Frankfurt. There is an official statement from Goldman's that they will move part to Frankfurt. There is an official statement from Citi that they will move part to Frankfurt. And by the way, also importantly, a part to Ireland, to Dublin. I think there is a statement from Bank of America, Merrill Lynch, that they will move to Dublin. And then there are unofficial statements which come to the public via the German Immobilienzeitung, the Real Estate Gazette, which lets people know that banks like Morgan Stanley or JP Morgan and others just tripled the size of their office space in Frankfurt. And as you will not find difficult to imagine, that means that those banks are likely to move more people to Frankfurt and to choose their venue for purposes of the EU passport for financial services and banking in Frankfurt. And in the case of Morgan Stanley, which I happen to know relatively well, the benefit of Morgan Stanley is they already have a fully licensed bank in Germany, Morgan Stanley Bank AG, so they are in a particularly comfortable position, and I think others will follow suit. Background is banks can't wait until the very last minute and can't wait until they see what's the outcome of Brexit. They will need at least a year in order to properly prepare, and that's not only about having the necessary regulatory approvals, that's also about renting office space, about accommodating office space, about making arrangements with the people to move. This is about infrastructure for the families of the people who move, about schools and kindergartens and flats and everything. That is not something you could organize the next day or even the next month. That takes some time, and again, certainty for those people is important. But really also very important to see the dimensions. I think John rightly stated, and also Laura before that, London is the financial capital in Europe, and it will remain for many, many years. So we're not seeing massive movements to Frankfurt or to any place. This is very gradual. This is tiny compared to the size and the importance of London, but it's starting. There are some movements, and I must say I'm kind of sorry for London and for the UK, because I feel that will deprive the UK of some of the privileges it has right now.
Thank you, Christoph. Sorry, on that, yes, kind note. I think we have to wrap up. It's been an absolutely fascinating session. Thank you so much to the panel. We have had some interesting questions coming in as well, which we will look at dealing with. We'll also do a write-up of this session and perhaps incorporate those questions then. I would like to thank the panel, Cecilia Carrara, John Cronin, and Christoph Wolff, very much indeed. There is more information, plenty more information about Brexit on Practical Law. And other than that, thank you very much for listening, and again to our panel.
Thank you.
Thank you.
Thanks.
Thank you.
Thanks.